I'm a housing I'm a housing attorney at New Mexico Legal Aid, and I also have Bryce Dorado here helping me with the presentation. So this is just for a disclaimer, this is just the basics of landlord-tenant law and for informational purposes only. It's not legal advice. If you need legal advice, you can contact the New Mexico Legal Aid intake line or a lawyer. Okay, so New Mexico landlord-tenant law is governed by the Uniform Owner-Resident Relations Act, but that's also supplemented depending on the type of housing and if there's a subsidy like a Section 8 voucher or it's public housing by other federal laws and different regulations, including HUD regulations, USDA rural housing law and regulations, the Internal Revenue Code, which governs low-income housing tax credit properties, federal laws like the Violence Against Women Act, the Fair Housing Act, the Americans with Disabilities Act, the CARES Act, and then also the New Mexico Human Rights Act, and then local human rights ordinances and local municipal codes also govern some housing issues. But in general, today we're going to be talking about the Uniform Owner-Resident Relations Act. And under the Uniform Owner-Resident Relations Act, in order to file an eviction or terminate a tenancy, a landlord must always give a pre-termination notice, a pre-eviction notice. And depending on the type of notice, the tenant has the right to cure prior to the landlord being able to file for eviction. So there are different types. The most common one is non-payment of rent, and that is a 3-day notice. The landlord has to state the amount owed and the method the tenant can pay it, and that with that the tenant has 3 days after the service of the notice to pay the landlord the amount owed and avoid eviction. If the amount isn't paid after those 3 days have passed, then the landlord can file in court for an eviction based on non-payment of rent. Of course, the tenant has the right to wait to a hearing and doesn't have to move out when they receive any of these notices. For violations of the lease other than non-payment of rent, there's a notice of material non-compliance, and that's a 7-day notice. And that's for things like throwing a loud party, having an unauthorized occupant in the unit, causing damages to the unit, different things like that. With the 7-day notice of material non-compliance, the tenant does have the right to cure. So oftentimes the way to cure would just be by not doing the thing again. Don't hold another loud party. Get rid of the unauthorized pet in your unit. Something like that. Or if the pet is a service animal, request a reasonable accommodation, something like that. But the notice of noncompliance has to be given by the landlord within 30 days of the violation, or the landlord waives the right to give the notice based on that violation. And of course, the tenant does have the right to cure the first time. If there's a second 7-day notice within 6 months, for that second 7-day notice, even if it's a totally different issue, the tenant doesn't have the right to cure. And after the 7 days have elapsed, the landlord can then file for eviction based on those notices of noncompliance. The third type of notice would be a substantial violation notice, and that's for very serious violations of the lease agreement. So essentially felonies. There are 7 very specific things that are 7-day that are 3-day substantial violations, and that's unauthorized use of a deadly weapon, physical harm to another person causing serious bodily injury, but there are 7 very specific things. And with a substantial violation, a landlord can give a 3-day notice. It has to list the specific substantial violation, and the tenant does not have the right to cure. So the landlord can then wait those 3 days after giving the notice and file for eviction, regardless of whether or not the tenant fixes any issues. If the tenant did not commit the substantial violation or consent to it, consent to a guest doing it, then it's not a substantial violation. The landlord would have to go to court and prove that the tenant did it, or the tenant consented to a guest doing it. Oral threats, like threatening to physically harm someone without more, is not a substantial violation of the lease agreement. And the last type of notice a landlord can give, and a tenant can also give this type of notice, is a 30-day notice at the end of a lease term. So once the lease term has expired, and it typically automatically reverts to a month-to-month tenancy, either the landlord or the tenant can give a 30-day notice. There's no cause required generally. However, for certain subsidized properties, the landlord does have to include cause in the 30-day notice. So that would be project-based Section 8, public housing, USDA housing, LIHTC complexes, and the landlord has to have a specific reason for giving that 30-day notice. But of course, a tenant can also give a 30-day notice and is not required to have cause for termination. The 30-day notice has to be given 30 days before the next rent is due. If it's given later, so for example, if it's given in the middle of the month, it's not effective until the end of the next month. So if a landlord were to serve a 30-day notice to terminate a lease agreement on June 15th, it wouldn't be effective until the end of July. And then if the tenant has not vacated after those 30 days, the landlord can then file for eviction based on that 30-day notice as well. So again, the owner has to wait until the notice period, depending on the type of notice. That would be 3 days, 7 days, or 30 days before filing for an eviction. If the landlord files prior to the expiration of those notice days, then the case needs to be dismissed by the judge. If the last day for a tenant to vacate or cure, like 3-day notice, falls on a Sunday, a weekend, or a holiday, then the tenant has until the end of the next business day to either vacate the property or cure the issue. And it's not clear in the law whether or not that's calendar days or business days, but there's a strong argument that for at least notices like 3-day notices of non-payment of rent and 7-day notices of non-compliance with the lease agreement, it should be business days. And when a landlord files for eviction, it can only be based on one of the listed items in the notice. So the landlord can't give one notice for non-payment and then go to a hearing and say, yeah, well, the tenant also has this dog in the unit. And if the landlord never gave notice for it, it can't be part of the eviction case. Okay, the CARES Act 30-day notice. So the CARES Act was passed in response to the COVID pandemic in 2020, and it had a temporary moratorium on evictions for covered properties. That piece has since expired. Covered properties include properties that are subject to VAWA, so all subsidized properties, public housing, Section 8, multifamily housing, LIHTC properties, and also any properties, even just a private landlord that has a federally backed mortgage. And the one relevant piece of the CARES Act that is still in effect is a requirement that with a notice of non-payment of rent, the landlord has to give a 30-day notice. So if a tenant has a Section 8 voucher and hasn't paid their portion of the rent, the landlord, instead of giving a 3-day notice, has to give a 30-day notice under the CARES Act and wait those 30 days, give the tenant the opportunity to cure. And if the tenant still hasn't cured at the expiration of the 30 days, the landlord can then file for eviction.
Hey, Riley, can I interject? In properties in this, so say there's a complex in which one person has a Section 8 voucher. but no one else does. Does the term covered properties apply to the whole, everyone else's unit, including the Section 8 voucher holder?
It does, although judges may not interpret it that way. But there is definitely a strong argument it applies to everyone in the complex, not just the person with the Section 8 voucher. Okay, the New Mexico Supreme Court stay is no longer in effect, but there was, along with the lifting of the stay during COVID, there was a eviction prevention and diversion program in which the court could send parties to mediation. And we are sort of hopeful that the court will continue these mediation processes and allow parties to the opportunity to mediate. But of course, it's not mandatory, and both parties have to agree in order to participate. Okay, repair issues. So this is a frequent thing that comes up. Tenants are complaining of repairs needed in the property, and the landlord just isn't making the repairs or hasn't addressed them yet. So in order to get a landlord to make repairs under New Mexico law, the tenant should give a written notice, including the specific repairs that are needed. And it doesn't necessarily have to be a form, a 7-day notice of abatement. It could be a letter, an email, an online portal request, but the tenant should make sure that they keep a copy of that written request for repairs. And when a tenant does make a written request for repairs, the landlord should make those repairs within 7 days. If the repairs aren't finished in 7 days, the tenant can withhold 1/3 of their daily rent going back to the date of the notice through the date that the repair is completed. And for subsidized tenants, like tenants with a Section 8 voucher, it's 1/3 of the total rent, not just their portion of the rent. So often for people with Section 8 vouchers, that almost covers their full portion of the rent. The tenant can also, if the repairs are really bad, give a 7-day notice and say, if this isn't addressed within 7 days, I'm terminating the lease agreement. The tenant in that case has to be prepared to move out in 7 days, but they can't terminate the lease agreement if the landlord makes an attempt to fix the issue. So the landlord doesn't have to necessarily complete the repairs in those cases. If the unit is completely uninhabitable and the tenant vacates until the repair is complete, so the tenant can't live there at all, then they can withhold 100% of the daily rent. The tenant can't abate for an amenity, so like a broken dishwasher, a broken washing machine. The law says the tenant is not allowed to withhold rent for those issues. And I have a question. Sending a text message to ask for repairs. Yes, that is a legitimate writing to ask for repairs. It's just good for everyone if both parties keep good records in writing. So if a tenant asks for repairs by text message, they should take screenshots of those text messages showing the date and time that they made the request. All right. And also feel free to interrupt me with any questions if anyone has any questions that come up.
So Riley, I got a question for you. Is swamp cooling considered an amenity, or is it considered the unit as uninhabitable in the summer?
In the summer, that is not an amenity. Air conditioner, especially like in Albuquerque where it gets really hot in the summer, it could make the unit uninhabitable. So it's not an amenity. That would be like a utility sort of issue.
Right, like if the lease requires the landlord to provide gas and electric, and then the gas or electric gets shut off for whatever reason, that's the landlord's fault, then the tenant could debate and say, you've got to get the electricity on. I can't live here without electricity. And if the power doesn't get turned on by day number 8, they could just move out and say, I'm done, no early termination fee, I'm out. I can't live in a house that's allowed with no electricity, and you don't want to spend $3,000 to redo the circuit breaker, so I'm out.
Right, exactly. But of course, it's a lot harder to move in 7 days than sometimes people think. So the tenant should be very prepared to move out at the end of those 7 days if they want to give that type of notice. All right. Let's see here. Right of entry. So the landlord does have a right to enter the unit to inspect or make repairs. However, a landlord has to give a 24-hour written notice of their intent to enter a rental unit before actually going in. And they have to serve that on the tenant. The notice should say the purpose of the entry. So for example, inspection, pest control spraying, something like that. And it should include the date and a reasonable estimate of the time frame of the entry. And a lot of times we see these notices that say will be in your unit sometime between 8 a.m. and 5 p.m., which is arguably not a reasonable time frame. You can't expect a tenant to sit in their unit all day waiting for a landlord to show up to do an inspection. The tenant can propose alternative times and dates if they're not available, and the landlord is required to attempt to reasonably accommodate. So if the alternate dates aren't a time that the owner is available, they should try to work together to find a different time that works for everyone. However,
link.
a landlord is not required to give written notice to enter a unit if the tenant has requested repairs in writing. So if the tenant requests repairs, the landlord's not required to give notice to go in and make those repairs. And then also if a public official, like for example, code enforcement or someone from PNM is with the landlord, they don't have to give that written notice when entering the unit. And the law also does say the owner shall not abuse the right of access. So if a landlord is constantly going into a unit and doing inspections repeatedly, for example, as a way to try to find a reason, try to find a lease violation to evict the tenant, that's not allowed. And the tenant, if the case ends up in court, the tenant could ask for an injunction, asking the court to order the owner not to go into the unit unreasonably. Okay, domestic violence.
Hey, I got a question for you.
Yes.
So if a landlord's doing monthly pest control treatments and they put a notice on the door at least 2 days in advance saying, hey, it's time for the monthly pest control, you know, we come by on the second Tuesday of the month in the morning to look for roaches and then spray if we find them, that would be reasonable, right? Because they're providing a service, they're doing maintenance, they're giving notice in advance, the tenant knows when to expect the pest control people, right?
Yes, that's definitely reasonable. Unreasonable, I've seen situations like where a landlord is going in every day or every week just for an inspection, which seems pretty unreasonable. But if they have a legitimate purpose for being there, then that's of course reasonable. All right, so domestic violence. There is a federal law called the Violence Against Women Act. It doesn't just apply to women. Any person that has been subjected to domestic violence can claim protection under this act. And this applies to federally subsidized properties. So it would apply to people with Section 8 vouchers, low-income housing tax credit property, project-based subsidy, public housing. And in most cases under the Violence Against Women Act, the landlord can't evict the victim of domestic violence for an incident that's directly related to domestic violence. So the way this comes up frequently in my experience is that there was a domestic violence incident in a rental unit, and a landlord, and there was some damage, like damage to the wall or the door or something like that. And the landlord then gives the tenant a notice of lease violation for causing that damage. And if it's a covered property, then the tenant can claim protection under the Violence Against Women Act. For these covered properties, so any federally subsidized properties, the termination notice has to be accompanied by a notice of the tenant's rights under this federal law. It also provides for provisions to transfer a tenant to a different unit, and there are confidentiality provisions as well. So the landlord can't go and tell everyone about this tenant situation.
Hey, Riley, I have a question.
Yes.
What's the relationship, I guess, with VAWA and non-payment? Because to me, it's foreseeable that DV leads to someone taking money and not allowing the victim of, or taking money from the victim, right? And the victim can't pay rent. Does VAWA have any protections for non-payment?
I think that a tenant in one of these covered properties could argue that, hey, look, here's the situation. I'm the victim of domestic violence, and my abuser emptied all of my bank accounts and racked up a bunch of bills on my credit card. So that's why I can't pay rent. And I think that could be, you know, a defense. And they should including non-payment of rent notices also should be accompanied by a VAWA notice under this law. And New Mexico state law, the Uniform Owner-Resident Relations Act, also bars eviction for the victim of a domestic violence incident if the tenant gets an order of protection, and it's actually specifically if it's a 3-day substantial lease violation notice. However, in eviction cases, judges have discretion, so they can say if the tenant comes in to court and says, look, this is based on a domestic violence incident, here's the situation, the judge has discretion to choose not to evict the tenant based on those incidents. And I have another question in the chat here. Yes, the tenant could and should fill out a HUD form 5382 to certify that VAWA protections apply to them. If they're in a covered property, the landlord should have these forms available. You can Google it and find it online, and it's a certification. They can write out what happened and the protections they're claiming, and then the owner, the housing authority, has to address those issues and try to find a way to accommodate them, like, for example, transferring to a different unit. All right. No cause evictions in federally subsidized project-based properties. So this doesn't apply to Section 8, people with Section 8 vouchers or other kinds of federally subsidized vouchers. But for properties like public housing, low-income tax credit properties, any kind of property generally where the tenant has to recertify their income every year, the landlord is again not allowed to evict without good cause. So they can't give that 30-day notice of termination of lease without specifying a reason. And that's an issue we see frequently, landlords that are subject to these federal rules trying to file for eviction based on a no cause 30-day notice. So the Fair Housing Act is another federal law. Generally prohibit discrimination against tenants on the basis of race, gender, religion, national origin, or disability. So that would be in terms of like renting to a tenant. You can't say, I don't want to rent to you based on your race, gender, familial status, etc. And then other types of discrimination, like harassing a specific tenant because of their race or gender or whatever protected class might apply. And the Fair Housing Act and other federal laws also require that a landlord reasonably accommodate a tenant with a disability, so that the tenant can have the same access, the same enjoyment of the dwelling unit as non-disabled tenants. So for example, a tenant that has disabilities and needs a service animal to help them with their disabilities, but the complex doesn't allow animals, the tenant can ask to have a service animal allowed in the complex as a reasonable accommodation for disabilities. And the Fair Housing Act applies to owners that have 4 or more units. So it would not apply to just someone who has 1 rental unit and nothing else. Some other examples of reasonable accommodations that are pretty frequent are asking that the landlord change the rent date without charging the tenant a late fee, so that the rent due date coincides with the payment of benefits like Social Security, disability, or any other type of income like that, benefit income. Tenants could also ask for an extra bedroom for a live-in caregiver or for medical equipment. And then another thing that comes up as well is asking the landlord to disregard some kind of notice of lease violation because that violation is due to the tenant's disability. So for example, if someone has a disability that causes them to get loud sometimes and the landlord gives a notice for disturbing other tenants, the tenant can ask that the landlord disregard that issue as a reasonable accommodation for disabilities. And when a tenant requests a reasonable accommodation, it doesn't have to be in writing, but it is always a good idea to put it in writing. We advise people to put everything in writing, landlords and tenants. It is always best. Way easier to prove who said what and when if it's in writing. So when a tenant requests a reasonable accommodation, the landlord can then either just agree to it, or can request a letter from the tenant's doctor to verify the disability and the nexus between the disability and the requested accommodation. So the requested accommodation has to be related to the specific disability. And the owner, if the owner is choosing, is going to try to refuse the reasonable accommodation by saying it's unduly burdensome or causing financial harm to the landlord, they should engage in an interactive process with the tenant to try to figure out some alternative that works for both parties. So the city of Albuquerque recently-ish passed a new source of income discrimination ordinance. So it amends the human rights ordinance to prohibit discrimination in the sale or rental of housing based on source of income. So that includes wages, benefits like SSI and SSDI, and vouchers. So specifically, landlords can't refuse to accept tenants just because they have a Section 8 voucher. Likewise, the landlord can't set the rent higher so that the voucher won't be able to be used at that unit if it's particular to a person with a Section 8 voucher. The landlord can't exclude benefits or voucher payments from minimum income calculations when determining whether or not to accept a tenant at a particular complex. However, if it applies to the entire complex and not just those tenants with a Section 8 voucher, the landlord can set rent higher than the payment standard that the housing authority that the tenant with a Section 8 voucher has set. And the landlord can also reject a tenant with a voucher if the housing authority doesn't perform their housing quality standards inspection within 5 business days of submitting the request for approval of that unit. It doesn't apply to buildings with 4 or less rental units if one of them is owner occupied, and there are penalties up to $500 and or 90 days in jail. And then the city of Albuquerque can also address complaints for violations of the source of income ordinance. And for properties that are low-income housing tax credit properties, so around Albuquerque, that's like Arioso apartments. There's a whole list of them. They are required to accept Section 8 vouchers.
And Riley, is there a similar law for Bernalillo County?
There is, yes. There is a county ordinance that's almost exactly the same language. So even if it's Bernalillo County outside Albuquerque, that applies. All right, I see a question. Charlene, I don't know what 5-day means.
Hello, hi. So I just had a question of the 5 days that they have. So one of the issues that we're facing is, so when a person does turns in a RAFTA, the request for tenancy approval, we need a certain number of documents per HUD that need to be part of that RAFTA. And a lot of times they will get turned in without those documents in place. And so is it fair to state that the 5 days from the time we get a completed RAFTA, specifically since the directions on the RAFTA state we need those documents? That was an issue we're kind of kicking around the office right now that just not sure.
I would have to go back and look at the specific language of the ordinance, but I mean, I think that is fair to say that a completed request for tenancy approval is what counts. But I would have to go back and look. I don't know specifically what it says.
Okay, I was just wondering if that was something that came up on your guys' end yet.
Not yet. I haven't seen it yet, but I'm sure I'm sure it will. All right. So some tips before renting a unit. Both parties, both owner and resident, should do a walkthrough inspection together. And it's a good idea for both parties to document it in writing and keep a copy. So list everything that needs to be repaired when the tenant is moving in. Take pictures of how it looks on move-in and save those pictures with the date, so you can prove that that damage existed when you moved in, or the landlord can prove that damage didn't exist when the tenant moved in. Either way. And sign a written lease. It is required by the law. And Brian, you look like you want to say something.
I was just going to say, and then New Mexico Legal Aid publishes a nice sample form checklist for walkthroughs on the back of your renter's guidebook, right?
Yes.
And is there a new version for 2023?
There is a new version in the works. I am working on it. I promise it will come out soon. It's on my calendar for next week. So
cool. All right, but the prior version still works. Yeah, I was just curious. But yes, and then also Albuquerque Housing Authority gives away a free template lease. So if there's anyone out there that needs a blank lease template form, we give those out.
I have a question.
Yeah.
I heard somebody complain recently that when they moved into the unit, it was dirty, and they were upset about that and like wanted to have a remedy for that. And is that actually legally required for a unit to be clean when you move in?
I think it sort of depends on what the landlord has said about the unit. But I mean, I don't think it's legally required for the unit to be clean, but it would be if the tenant.
They couldn't say you left it dirty if it was already dirty.
Yeah.
Yeah.
Yeah, they should take
It's
pictures.
more of a courtesy, I think.
Yeah.
Yeah. And then I also wanted to ask about, what about repair issues that are not like a code violation? It's just like something's broken and they want it repaired. something a little bit more minor, do
Mhm.
they have those like abatement remedies, or what do you advise for those things?
Yeah, a tenant can still abate rent even if it's not like a code violation. So if there's, I mean, that's typically the ones we see, but if there's, you know, none of the doorknobs in the house lock or something like that, a tenant should give a notice, requesting a written notice requesting that the landlord make those repairs. And typically the thing with abatement is that when a tenant withholds rent, regardless of whether or not they have a legitimate reason, the landlord will then file a case, an eviction case, because the tenant has withheld some portion of the rent. So that's why it's a good idea to make sure everything is in writing, take pictures of the repair issues, and they can go to court and say, no, I just withheld this rent because these repairs aren't being made. And then the judge can decide, if the judge decides that they weren't entitled to withhold that money for whatever reason, then the law says the court can issue what's called a conditional writ of restitution, which gives the tenant 3 days to pay the amounts they wrongfully withheld. And if they pay within those 3 days, they shouldn't be evicted. So that's sort of the process. Or the court can apply equity and say, yeah, you withheld the wrong amount or for these things, but I think these other issues you could have withheld for, so I'm not going to evict you and you don't owe this money. But it's just a good idea to keep documentation of all of those things.
Riley, can I add to also keep, it's always a good practice to keep the amount that for the tenant to keep the amount they withheld aside, in case it does get to court so they can pay.
Yes. Very good point. All right. And so some tips, well, leasing a unit, any changes to the lease agreement or the, you know, terms of the tenancy should be agreed to in writing. Again, always document everything. So if, you know, you have a new roommate moving in and your landlord agrees to add this person to the lease, that should be in writing, clearly documented so that both parties know this is the agreement. You can use lease addendum forms to add a resident or remove a resident if someone moves out. Change the amount of rent if both parties agree. A landlord is not allowed to raise the rent during the terms of the lease agreement. And in a month-to-month tenancy, they have to give a 30-day notice to increase the rent, or to add or remove a pet or service animal. Address problems like repair issues in writing. Again, if repairs are needed, ask for them in writing. If the landlord has some issue with the tenant, they should put that in writing and document it. Keep copies of all communications. So text messages, save those text messages, save those emails. Take photos of the notice. If you're the landlord and you're posting notices, you should take photos to show that you posted those notices. Or if you're the tenant giving a notice to the landlord, you should take a photo or take a witness with you so you can say, look, I gave the landlord this notice on this date. And with all rent payments or any other payments, the tenant should always ask for a receipt and the landlord should always give a receipt. That way it's very clear to everyone what was paid and when, which is a subject of frequent dispute in court. Let's see. And can people use certified mail and email? Yes, of course, that is a great way to keep documentation of things. Service of a notice under the law can't be necessarily by email. So if a landlord is serving one of those termination notices, I would argue it's not valid service because the law specifies the way it should be served. But I don't know how a judge would rule on that. Certified mail is also great because you get that return receipt saying when it was delivered. A check is not technically a receipt, but a copy of the check is good proof that that amount was paid, and especially if you have bank statements showing that that amount was taken out of the account. All right. On tips on moving out. For tenants, they should clean the unit, take lots of pictures showing that they cleaned and the good condition they left it in. Make sure that they return all door and gate keys, any garage remotes, all of the keys. And they should always provide a forwarding address, if it's a PO box or a friend or family member's address or their new address, to the landlord in writing, so that the landlord can send the refund of their deposit or any itemized statement with deductions from the damage deposit to them after move out. And the tenant should ask for a move out walkthrough inspection with the owner to look through and see if anything's damaged. Sometimes during these walkthroughs, the tenant will say, "Oh, I accidentally caused this little thing." The owner will say, "Don't worry about it," and then the tenant thinks it's resolved and the owner thinks it's not resolved. So good idea to do the walkthrough and record it maybe. For owners and managers, again, do a move out inspection, a walkthrough of the unit, take pictures of all of the damages. And the law requires a owner or a manager to send a itemized statement listing any deductions from the damage deposit or a refund of the damage deposit to the resident within 30 days from the date of move out. If the landlord doesn't do that within 30 days from the date of move out, they lose the right to withhold any portion of the damage deposit, and the tenant could file in court for return of the damage deposit, plus a $250 civil penalty for bad faith withholding of the damage deposit, which is almost never granted. Um,
Can they also
Are-
get attorney's fees?
what's that, Brian?
And can they also win attorney's fees?
Yes, yes, they can. And the reason why it's important for a tenant to provide a forwarding address is because the law just says that the owner is only required to send it to the last known address. So oftentimes if the tenant doesn't provide a forwarding address, then that's just the rental unit itself, the last known address of this person, and the tenant doesn't get their itemized statement or their refund of the deposit. So always provide a forwarding address. All right.
What if you agreed to pay a bunch of flat fees in your lease? Is that legal?
A bunch of flat fees like against the damage deposit?
Yeah, like a standard cleaning fee or a carpet replacement fee or something like that.
Yes, that is legal. I see that sometimes. It's yes, a landlord can. If the parties have agreed to these terms by signing the lease, then that's allowed. And I have a question. What does the law say about abandoned property left by an illegal squatter? There are different sort of situations regarding what an owner should do if there's property left at a unit. In the case of, I don't think that if it's not a tenant, there's no legal obligation of the person to keep that property, but in that case, the owner is still required to go through a court process to remove an illegal occupant in a unit. However, I would say it's always best practice to try and give that any person, tenant or former tenant, someone who's been evicted, someone who's not legally there, notice of intent to dispose of property, and that protects against any potential lawsuits there. Okay, so for the court process, after the notice period expires, the pre-eviction notice, the landlord can file a petition for restitution in either magistrate or metropolitan court in the county where the rental unit is. Here in Albuquerque, it's metropolitan court. In the rest of the state, it is magistrate court. The court will set the hearing 7 to 10 days after service of the summons. So once the tenant gets served, the hearing should be set 7 to 10 days after that. For the past couple of years, trials have been remote. However, starting on June 20th in Metro Court, the hearings are going back to in-person. Around the state, it seems like most courts are going back to in-person hearings, but some still have options to sign in via Zoom or Google Meet or phone. And also a party can also file a motion before the hearing asking to appear remotely, either by video or by phone, and hopefully a judge will rule on that and grant it before a party has to travel to get to that hearing.
And Riley, I got a question for you. So what are good grounds for requesting the permission for virtual appearance versus not good grounds? So if any judges enumerated, I'll do it for this, but I won't do it for that.
I would say, I've done, prior to COVID, I did request to appear remotely due to disabilities. So if someone has mobility issues and they physically can't get to the courthouse, then that's one grounds, something like that. Definitely anything disability related that's prohibiting a person, if it's unduly burdensome for that person to travel hours. So sometimes outside of Albuquerque, the magistrate court is pretty far away and the person might not have transportation. That might be a good grounds. And then in addition to that, parties are allowed to request a continuance, a reset of the hearing for good cause. So that could be something, especially in Metro Court, the judges tend to grant those motions for 7 days. So could be something like I need time to find a lawyer, or I have a doctor's appointment at that time and I need the hearing reset, something like that.
Also, might it be like if you're dealing with an out-of-state owner, the Californian owns the rental property and they ask the court, can I appear remotely instead of traveling to Albuquerque for the hearing?
Yes, that would be another one. Definitely.
Yeah. Or maybe the tenant is in quarantine for COVID, they've tested positive, so they call the court and say, hey, I'm sick. It's like, well, let's put you on Zoom. We can still evict you while you're sick.
Yes. Yes, of course. All right, in terms of exhibits, I think most courts have now set up either an email address or a way for parties without lawyers to submit exhibits electronically. And Metro Court has a new email address. So if a landlord or tenant wants to submit any exhibits prior to the hearing, they can email them with the case number to that address, and I will put that email address in the chat.
Riley, in addition, each court has a website, right, that lists their contact information and people can always call and ask how to submit exhibits, correct?
Yes. Yeah, sometimes these email addresses aren't necessarily listed, but calling the court clerk can be very helpful if you're trying to submit exhibits before a hearing. And sometimes the notices of hearing attached to the summons or any subsequent notices of hearing will have information on how to submit exhibits as well. If the hearing is in person, I used to do this all the time, just show up with exhibits to the hearing and introduce them then. But it's always a good idea, if possible, to send the exhibits to the other party before the hearing and try to submit them to the court before the hearing.
And why is that a good idea, Riley? So like the parties can come to an agreement, like we both agree that this is the lease agreement that applies to this case. And we both agree that this picture is true. And then maybe there's some argument about something else. So that way you can narrow the issues and just have the argument about the one thing.
Exactly. Yes.
And then also the other side might be more willing to settle if they realize, oh, they've got proof of that. I can't argue that anymore, right?
Exactly. All right. So the court will hold a hearing on the petition for restitution. Generally, the judge will ask the landlord to go first, sort of explain their position. They'll say, you know, how much rent does the tenant owe, or what violations are you claiming? What did you witness these violations, etc. And then the tenant gets the opportunity to respond. Both parties can present witnesses and can cross-examine one another. If the landlord wins, the court can enter a judgment for restitution, which could include any past due rent, utilities, and the landlord can claim court costs or attorney fees if they're the prevailing party. They can only ask for attorney fees if they actually have an attorney representing them. And then the court can also issue a writ of restitution, the order that tells the sheriff to go and evict the tenant. And typically those will be issued for 3 to 7 days after the hearing. So 7 days after the hearing, if the judgment says so, the landlord can go to Metro Court and pick up a writ of restitution, take it to the sheriff's office, and the sheriff can then go and have the tenant evicted by the sheriff. It is always illegal, even if the landlord has a judgment for restitution, the landlord cannot go to the property and change the locks himself. It has to be the sheriff. Yes, Brian.
Also, is it still the rule at Berlin County Metropolitan Court that you cannot bring your cell phone in with you to the courthouse if you're a member of the public, that you have to leave it outside the courthouse?
That is still the rule, yes.
And so if you're going to bring photos, you need to print them out and have them ready to go on paper with a copy to give to the judge, a copy for you to keep, and a copy for the other side.
Yes, and there's also a specific way at Bernalillo County Metropolitan Court. If you go in and talk to the security guard right at the front before you go through the metal detectors and say, I have a phone, I'd like to show pictures that are going to be exhibits as evidence, and the security guard will take the phone and list the hearing and the hearing time and take it up to the judge, and when your case is called, you can show the judge pictures on your phone if there's absolutely no way to print them out.
Right. So they won't end up in the file if you're trying to use it on an appeal, right?
Right. But
So,
of course, appeals under the Uniform Owner Resident Relations Act are de novo, so you get the opportunity for a whole new trial.
and then if you're trying to show a video in court, what would be the best way to make sure that video you've got of whatever you need to show the judge actually is presented and effective?
So call the court clerk days in advance and ask for a media cart to be taken to the courtroom for your specific hearing. And then you can make sure it's on a thumb drive, have a copy to the judge, the other party. But Metro Court is very particular about people asking for the media cart to be taken before the hearing. So that should be requested several days before the hearing.
And what if you don't speak English and you need a translator for another language?
And you can file a request for interpreter, and all of these forms are available at the Metro Court self-help desk. That should be filed ideally prior to the hearing, but if you show up to the hearing and request an interpreter, the court is still obligated to provide one. They have interpreters that work for the court that will come up and appear at the hearing.
And what happens if you show up late and you miss your hearing?
If you show up late and miss your hearing, you likely have a default judgment entered against you if you're a tenant. If you're a landlord, then your case has likely been dismissed if you've missed the hearing. And in that case, you can file a motion to set aside a default judgment. You would have to have a reason for missing the hearing. So I got in a car accident on my way to Metro Court. I was late, and you have to show a defense to the original action. So I got in a car accident, and the reason I haven't paid my rent is because the landlord hasn't made all of these repairs, and I have the pictures to show it. Something like that. It's a pretty straightforward form. Generally, the judges will set a hearing on that pretty quickly. As long as it gets filed, it should be filed before the date the writ of restitution is set to issue, and you can find that date on the judgment itself. And that's because once the sheriff has evicted a tenant, it's very hard to get back in the unit.
And speaking of the sheriff and an appeal, if someone files a notice of appeal in district court after the writ has already been taken to the sheriff, does anyone tell the sheriff?
I'm sorry, Brian. Oh, I was reading a question in the, repeat your question.
Oh, sure. So say the landlord has won a judgment for restitution. The tenant didn't leave. The landlord gets a writ of restitution and gives it to the sheriff. Here's the writ, sheriff, go serve the writ. You've paid the $40 to the Bernalillo County Sheriff, they're gonna go evict somebody. After that, and days later, the tenant files a notice of appeal in district court saying, wait, I'm appealing. Who tells the sheriff? Does the sheriff go ahead and serve the writ because they already have the writ? Is anyone going to tell the sheriff, don't stop, wait?
Well, the person who has filed the appeal, it is a very good idea to tell the sheriff immediately if the writ has already been issued. If it hasn't been issued yet, so for example, if a tenant files an appeal the day after the judgment and the writ isn't set to issue for several days, and then files that notice of appeal also in Metro Court won't issue the writs if there's a pending motion generally, or if there's an appeal before the writ has issued. But if the sheriff or the landlord already has control of the writ, definitely send a copy of the notice of appeal or any pending motions to the sheriff's office. And I usually advise people to also have a printed copy. So in case the sheriff comes, they can say, look, I have this appeal. You shouldn't evict me.
Riley, in case there are people here that aren't in Bernalillo County or going to Metro Court, what magistrate court's different about the dates in which when the writ issues or the eviction order issues, correct? Can you speak about that briefly?
Yes. So in magistrate court, generally with the judgment for restitution, the writ of restitution will also issue, but it'll have a date that's set 3 to 7 days, or sometimes a different day. It's sort of unclear to me how judges determine this, but a different day further out, and it'll say the writ is effective on this date. So the landlord, the day of the hearing, could go and take that writ to the sheriff's office, and the sheriff couldn't go and evict the people until the date it's effective. So in that case, in counties outside of Bernalillo, it's probably always generally a good idea to send any like a notice of appeal or a pending motion to the sheriff if the writ has already been issued. All right. So after the initial restitution hearing, if there are other issues, like the tenant wants their damage deposit back, they think the landlord has wrongfully withheld it, the landlord hasn't provided the 30-day itemized statement, or the landlord is claiming the tenant caused damages to the property, or there are other damages, either party can ask for a damages hearing at a later date. And sometimes in Metropolitan Court, those hearings are not set automatically. In some of the magistrate courts, those hearings are set automatically, like about a month or two after the initial eviction hearing. So if either party files an appeal, the appeal, if a tenant is filing an appeal and there's a writ set to be issued, it stops the sheriff from executing on the writ, from evicting the tenant, but the tenant has to pay post-judgment rent during the appeal. So that would include the first payment is due within 5 days from the date of filing the appeal or the court issuing an order setting this amount. And it'll say rent from the date that the judgment was entered through the end of that month. And so it's usually not a full month's rent. And then every month thereafter, the tenant has to pay the regular monthly rent as it comes due. So, so the tenant can stay in the unit during appeal as long as they continue paying the monthly rent. And if they stop paying the monthly rent during appeal, the landlord can go through the process, serve a 3-day notice of non-payment of rent, give the tenant an opportunity to cure. And if they haven't cured, they can ask the court for a writ of restitution. Okay.
And Randy, which court do they ask for the writ of restitution? Do they ask at the Metropolitan Magistrate Court, or do they tell the district court where the appeal is being heard?
They should tell the district court where the appeal is being heard because it is a de novo appeal. A brand new trial in district court. Some other issues that might come up. So if the parties have signed a lease agreement and for whatever reason, the landlord doesn't deliver possession to the tenant can terminate the lease agreement and get back a refund of prepaid rent and their deposit. If there's a fire in the unit that leaves it completely uninhabitable, the tenant can give a notice even after the fire has happened, saying it's my intent to terminate the lease agreement. And in that case, they should also get back prepaid rent and potentially deposit. Tenants often leave property after move out. There are different timelines for how long a landlord has to hold on to that before getting rid of it. In the case of eviction, it's 3 days. In the case of, so 3 days after the execution of the writ of restitution. The landlord only has to hold on to it for 3 days. And in the case of termination by mutual agreement, so the parties just agree the lease is terminating on this date, the tenant moves out, voluntary surrender, that's 14 days the landlord has to store the property. And during those either 3 or 14 days, the landlord, if the tenant asks, the landlord has to give the tenant reasonable access to get their property back. So the landlord can't say, no, I'm keeping your TV until you pay the amount you owe on this judgment. They have to give the tenant access back and they can't keep the stuff as a lien against any judgment. Okay, illegal lockout. So it is always illegal for a landlord to change the locks, shut off the utilities, otherwise attempt to or threaten to exclude a tenant from the property. They have to follow the court process and give the proper notice, go to court, win at court, and have the court issue a writ of restitution to evict the tenant. If the landlord does illegally lock out the tenant or shuts off the utilities or does something that otherwise excludes the tenant from the unit, the tenant can file a petition for restitution in either magistrate or metro court and ask that the court order they be reinstated to the unit, and they can ask for a civil penalty of 2 times the monthly rent if a landlord has illegally locked someone out.
And fees, right, Riley?
And attorney fees if they have an attorney. And the landlord should refund any rent for the days that they were not in the unit. They're not responsible for rent for those days. We already discussed appeals, and then there is also a separate law in New Mexico called the Mobile Home Park Act that applies when a tenant owns their mobile home but is renting the space from a landlord, and it's is it 12 or 14, Bryce?
12.
12.
Yes.
12 mobile homes in the park.
Or more.
Or more, yeah. And that has other specific notice requirements and protections because those people own their mobile home, and getting evicted, they would potentially lose the mobile home. But generally the eviction process is the same as that under URA, the Uniform Owner Resident Relations Act. And that is all. Does anyone have any other questions?
I do, Riley. It's Brian, if no one else does. So so for appeals, you mentioned they're de novo. Is that being followed in Second Judicial District Court in your experience?
So it sort of depends. This is an issue because prior to 2019, appeals from Metro Court, nowhere else in the state, but just from Metro Court under the Uniform Owner Resident Relations Act were on the record. So meaning the court only reviews what happened in the Metro Court, and the parties would have to file what's called a statement of appellate issues, outlining what they think was wrong with the lower court's decision. And then the law changed, but the courts haven't adopted corresponding rules to have rules for a trial de novo in the Second Judicial District Court. So generally, from what I have seen, the courts are asking parties to still file these statements of appellate issues and are deciding it basically on the papers. It's basically an on the record de novo review of what happened in the lower court. But based on like requests, the judges are setting actual new trial de novo in district court. I have one coming up here in July. So I think it's changing, and hopefully there will be rules adopted too that clarify the procedure for everyone.
Thank you. That's very helpful. And then can you explain when Uniform Owner Resident Relations Act would not apply and you'd need to do unlawful detainer? Because I've seen people in Metro Court get that confused, and the judge has to dismiss the case because it should have been unlawful detainer.
So unlawful detainer applies if there's no landlord-tenant relationship. So, for example, if someone is has illegally entered the property and is living there without authorization, or sometimes in the case of the way I've seen it come up frequently is some relative is living with another relative and not paying any rent, just there, and then some situation comes up and the owner of the property wants that other relative to leave, so they have to file under unlawful detainer, but it only applies if no monthly rent is being paid.
So this is how you get your 30-year-old son off the couch in the basement. Mom and dad can say, you have to go. Here's your 3-day notice to quit. And then you sue your adult offspring that's in the bedroom down the hall saying, you really got to go. I own the place, right?
Yeah.
Okay.
But you still have to follow the court process.
I've been getting a lot of complaints lately about landlords trying to change the terms of the lease in the middle of the lease. And like, I understand you could do an addendum by agreement, but it's being presented as like a mandatory change in policy. Like, up till now, we've included this utility in your rent, but now we change things and you have to pay this utility, or now we have mandatory insurance that you have to pay. And the tenants. So I guess for one, the first part of that question is that wouldn't be legal, right? And then the second part is like, well, what if the tenant, because it's presented as mandatory, just goes ahead and pays it? Have they now agreed to amend their lease because they did, or if they signed something that said that because they didn't know they had any choice?
No, that is not legal. A party cannot unilaterally change the terms of a contract without agreement by both parties. If it's a month to month, then that's different, but in the middle of a lease term, no. And for the second part of your question, I think there's kind of an argument both ways. I think, yeah, maybe that could be seen as like waiver of objections, like the tenant by paying the additional fees by signing this thing, they agree to it. But they could also potentially argue something, you know, like they were coerced into signing it, because that is probably something that happens frequently as well. Like a landlord will say, if you don't pay this, you're getting evicted, and so and I mean, URA does have a provision that says unlawful agreements are void. So I don't know. I think there's sort of an argument both ways.
Thank-
Brian.
Yes, and speaking of Uniform Owner-Resident Relations Act prohibiting certain illegal things, so it's illegal for landlords to have in their lease, for example, still, right, that they have to, the tenants have to waive the right to appeal, waive the right to notice, waive the right to jury trial. Those are all things the statute specifically says you can't make that illegal. You can't put that in the lease, right? There's certain things that are just prohibited.
Exactly. So the lease can't waive any of the rights provided to the tenant under the law.
So
So
like late fee, for example, it can't exceed 10% of the monthly rent. So even if the lease agreement says there's a $100 late fee for every day the rent's late, if the rent is $1,000 a month, the late fee caps out at $100, right?
exactly. Yeah.
And then also there would, if the lease agreement talks about this as a subsidized tenancy where rents are based on income and the amount of subsidy will vary as your income varies, that's where the rent price could go up if the tenant gets a job and they have more income, right?
Yes, the rent price could go up in a subsidized complex, but like for tenants with Section 8 vouchers, their portion of the rent could increase based on their increase in income. But a private landlord couldn't unilaterally increase the rent, the total rent of the unit, and ask the tenant to pay that increase.
Because what will happen is the landlord will keep getting the same amount of money per month, this theoretical $1,000 a month, but then the subsidy will decrease and the tenant's portion will increase. So landlord still gets $1,000 a month, but now they're getting more from the tenant and less from the housing authority, but it's still the same rent price ultimately. It's just who's paying it is shifting around.
Yes. Yeah.
And then speaking of vouchers, if people out there on the internet are looking for a housing choice voucher, Albuquerque Housing Authority is now taking applications for Section 8 housing choice vouchers from June 1st to June 30, 2023. Please apply on abqha.org. We only take applications for 1 month per year at Albuquerque Housing Authority for Section 8 Housing Choice Voucher Program. So if you want to get a housing choice voucher, now is the time to apply at abqha.org. And we will conduct an admissions lottery drawing after July 1 to figure out who to interview first. So it's not a traditional waiting list, it's a lottery drawing process. Thanks.
Hey, Riley, can I add to, well, maybe this is relevant and you can correct me if I'm wrong about Mari's question though, about changing lease terms mid-lease. It seems to me that often arises and it's often related to retaliation. So I'd keep an eye out for that too. But I could be wrong.
Yes. It is also illegal under the law to retaliate against a tenant if they've engaged in a protected activity under the statute. So requesting repairs, withholding rent for requesting repairs, organizing as a tenant association.
Is it ever, oh,
Go ahead.
sorry, my internet was cutting in and out.
Mhm.
Is it ever legal for a landlord to charge a tenant for a repair?
If if the tenant like caused the damage, I've seen lease agreements that say if any of these damages were caused by the tenant, then we're charging you for the repair. And I believe that like public housing also will charge the tenant if it's tenant caused damages. that are in need of repair.
Yes, and if it's beyond ordinary wear and tear. So for example, if the tenant has bashed a hole through the drywall, and it's fish shaped, we can tell it was done by a person, that sort of thing, that's beyond ordinary wear and tear. But the tile floor is wearing out because it's 30 years old and people have been walking up and down the hallway and the seam is starting to split. That would be wear and tear. So if fixtures are missing, Albuquerque Housing Authority always charges tenants when they steal the smoke detector or they remove light fixtures or doorknobs, because all those things are present when they moved in. So if you're a landlord and your tenant is removing fixtures that you can prove were there because you have the sign-in sheet when they rented the apartment, all the fixtures are there, you have pictures, that's definitely, in my humble opinion, a tenant caused damage because you rented them a doorknob, the doorknob needs to be there when they move out.
Unless neighbor removed doorknob.
Or it was removed based on domestic violence.
Right. Except for VAWA exceptions, but generally speaking, no one's gonna steal your electrical outlet plate.
All right.
I actually have a question.
Okay.
If a landlord retaliates against a tenant and the tenant decides to move, just to not go through that process right then, I was told by a lawyer that that they could take the landlord to court after the fact if they could prove the retaliation.
So I have done that sort of claim before, but retaliation under the law is specifically like when a landlord tries to evict or threatens to evict a tenant based on one of these protected things. And then if the tenant just leaves after that, they would still have those claims under the law. So they can claim that civil penalty of 2 times the monthly rent for if they can prove the landlord retaliated against them.
Okay. Is there a time limit about how long the tenant would have to take the landlord to court?
I think it would be based on a contract claim, so 3 to 6 years.
Okay. Also then would attorney's fees be able to be recovered? I mean,
Yes.
okay.
As for cases that are brought pursuant to the Uniform Owner Resident Relations Act, the prevailing party in a lawsuit can claim attorney fees.
Okay, thanks.
Bryce, one of you is going to say something.
Is rent control prohibited by state law?
It is, yes.
So landlords can charge whatever the market will bear?
Exactly.
And then also, does the city of Albuquerque have a law regulating application fees, how large they can be?
No, it did not pass.
So landlords could charge an application fee of 1 month's rent if they wanted to?
Theoretically, they could.
Now, the state law limits damage deposits though to 1 month's rent, right?
Yes. 1 month's rent. I think if it's higher than that, the landlord has to put it in an interest-bearing account and include that interest in the when they reimburse the tenant at the end of the tenancy.
And then can they charge a pet deposit on top of that?
They could charge a pet deposit.
Thank you.
Yes.
Brian, just doesn't the amount, well, Riley can clarify this, but the amount of the deposit or how much a landlord can charge depends on the length of the lease as well, though.
Yes, it does. I think it's for leases longer than a year, they can charge more than 1 month's rent. All right, any other questions?
Parking regulations. Can landlords have special rules about who parks on their property if you're a tenant?
Yes, they can.
Can they charge extra for parking?
They can. I think there are certain situations where I would argue that's additional rent and it's not illegal under, or it's not legal under federal law. Like, for example, if the tenant has a Section 8 voucher, but
And then where can people find information about affordable housing if they're struggling with paying rent?
the MFA, the Mortgage Finance Authority, has lists of both subsidized properties and affordable housing, which are generally low income housing tax credit properties, all over the state. So you can search by city.
That's the housingNM.org.
Yes.
And if someone wants to become a client of New Mexico Legal Aid, how do they apply to your firm?
They should call our intake line, and I can put that number in the chat. Where it's open Monday through Thursday from 10 to 3, and then people can also fill out online applications. But we do not recommend that if there's a hearing coming up very soon. It's better to call the intake line.
And how soon is very soon? Like 3 days or less, or?
Like a week or less, I would say.
Okay. And can legal aid represent both landlord and tenant, or just one side or the other?
We have income limitations on the clients that we can accept. So we can only represent people that make 125% or less of the federal poverty level. So that generally excludes landlords. There will be the occasional situation like, grandma wants to get her grandson off the couch in the basement where someone may qualify, but other than that, generally we can only represent tenants.
And then other options would be like the modest means hotline at the State Bar of New Mexico if someone's over the income limit for legal aid, or there's a conflict of interest. That would be another option, right?
Mm-hmm.
They can visit nmbar.org to visit the State Bar website.
Or the UNM School of Law.
Oh yeah, the law clinic, that's another good option. And then for elders in the Bernalillo County metro area, they could try Senior Citizens Law Office if they need legal advice as well, and legal aid's full.
Yes, but I think it has to be 65 or older for the Senior Citizens Law Office. I'm not sure about that.
Yeah, that sounds about right. Visit their website for details. Yeah, the Senior Citizens Law Office, another nonprofit. Any other places around the state that we can refer people to if they need legal advice?
If you're over, I think 55, there's something with the word elderly in it that you're referred to from the modest means organization.
Legal Resources for the Elderly.
Yeah.
And it's that's just telephone advice. They don't represent people in court.
Okay.
So yeah, Legal Resources for the Elderly program at the State Bar of New Mexico is a good example of a free legal advice hotline. So you at least can talk to someone over the phone and find out if what you're doing is legal or illegal. Do you have a case or not,
And to clarify, in case it's relevant to matters to anyone here, Senior Citizens Law Office, I believe the age threshold is 60 and above. And in certain circumstances, legal aid can help people that make between 125 and 200% of the federal poverty.
And then for New Mexico legal aid, do clients have to be a U.S. citizen or have eligible immigration status?
Yes, they do.
And for folks that don't, are there other nonprofits that they get referred to?
The New Mexico Immigrant Law Center will occasionally do some housing cases. So we refer people there. There are also workshops like this where people can just get legal information. And let's see what other organizations.
And now, Riley, if someone's already got a judgment for restitution, they've already been evicted, can legal aid help them undo that?
Potentially. It's an uphill battle, but if they're
So they should contact your firm and see what can be done, right?
that, yes. Okay, anything else? All right. Well, thanks everyone for attending. Thanks for the quiz on housing law. And we do these workshops every quarter, so so March, June, September, and December, and it'll be virtual. So spread the word if you know people that would like to attend or have issues that they want to learn about. All right. Thanks, everyone.
Thank you.